Good morning, and welcome to the program. I am Takashi Takashima, legal officer with the International Trade Law Division of the UN Office of Legal Affairs. I would like to begin by extending our sincere thanks to Sciences Po Law School for partnering with us to make this event take shape, and also a special thanks to the speakers who are joining us today to contribute to this program. Before going into the discussions, I would like to provide a brief overview of the project we are implementing to put the discussions into context. The project that UNCITRAL is implementing regarding dispute resolution is officially called the stocktaking of developments in dispute resolution in the digital economy. And the acronym of dispute resolution in the digital economy is DRDE. So in short, we call it the DRDE stocktaking project, or even shorter, stocktaking project. The project was launched by the Commission in 2021, and it conferred on the secretariat the mandate to monitor the changing landscape of dispute resolution in the digital economy. Specifically, what the secretariat is tasked to do is to compile, analyze, and share relevant information. And because UNCITRAL is a legislative body, we do that with a view to laying the groundwork for possible future work on updating UNCITRAL texts or developing new ones if necessary. From the Secretariat's perspective, we think a little bit further and we ask ourselves three questions. One is, what are the technological means, new and conventional, used in dispute resolution these days? And two, how has practice adapted to the integration of technological means? And three, is whether or not there's a need for new UNCITRAL texts or need for developing new ones. The focus of the project is twofold. One is the disruptive aspects of digitalization and dispute resolution, especially those with respect to due process and fairness. And the second is enabling aspects of technologies, especially those with respect to impact on cost and duration. Here you will see a list of topics that the project has been taking up so far. This is a result of extensive scoping exercise. I'll just read them out, so in case the bullet points are not clearly visible. How can legal frameworks be adjusted to be more conducive to the issuance and enforcement of electronic arbitral awards? How can case management be done better to address the problem of information overflow? What are the latest technological means used for the presentation of submissions and evidence in arbitration? How are hearings in arbitration and mediation conducted online? Where are we in terms of AI-assisted decision-making or AI decision-making? What can be done so that practice on interim measures is up to speed in the digital economy? And finally, what are the safeguards needed for and principles applicable to dispute resolution on online platforms? Some questions will be addressed in the discussions that will follow today. Here you see a list of work that the Secretariat was tasked to implement in the lead up to the Commission, and also at the Commission session to take place in July this year. You will see in the first bullet point that the Secretariat will be reporting to the Commission on the preliminary findings of the project at the 56th session coming up in July this year. And as we do so, we continue to conduct our own research, but at the same time, we are organizing discussions to seek inputs from different parts of the world so as to ensure that the perspectives from different regions are properly reflected. And And as gender is a cross-cutting issue that is of high priority in the implementation of the project, we constantly explore areas where gender perspectives may be introduced. The straightforward way to seek input from different regions around the world is to go there. And so we have embarked on an initiative called the World Tour, which was started in Tokyo in December last year. And then we traveled to New York in February. And the latest discussion we had before our event today is the one we had earlier this month in Guatemala City. So here we see a list of upcoming discussions. The Paris event is taking place just now. We have one scheduled in Vienna in May, and we are hoping to organize a discussion in MENA region and also in sub-Saharan Africa, and also the one that is starting to take shape is one in Oceania. So let us just take a quick glance at what was discussed in previous events. I just refer you to the discussions at the Tokyo Forum and also the LAC event, because the two events both cover all the aspects that the Secretariat wished to cover and follow the same pattern. 3 panels were organized, and the topics of use of technology in arbitration, online mediation, and dispute resolution on online platforms were discussed in the respective panels. Because we are discussing arbitration today, I'd just like to draw your attention to what was discussed in panel 1 on the use of technology in arbitration. The specific topics were electronic communication and e-awards, case management, e-document production, new forms of presentation of submissions and evidence, online hearings, AI in the decision-making. The 2 topics highlighted in yellow, I would like to go a little bit further into detail, hoping that it might make a good segue into some of the discussions that will follow. So on electronic communication and e-awards, what was said in both events were that predominant means of communication and arbitration was electronic and not paper-based. That is, that email and file share and case management platforms were used. But at the same time, the exception was notice of arbitration and also awards. And in support of this statement was a result of a survey shared by Professor Maroud of Ghent University. I have sought her kind permission to present this again and share this with you today. Here is a pie chart of the result of this survey. And she has also kindly provided me with a note on what this actually means. You might not be able to see the figures in the pie chart, but I will just like to quickly describe what this tells. So the survey was sent to arbitration institutions that are considered leading on a global or regional scale. Specifically, it was sent to 43 commercial arbitration institutions and were responded by 22. 32 of the institutions responded that they send awards exclusively on paper form, which is the blue part, and 10%, which is 2 institutions, responded that they issue electronic originals. The majority of the institutions in orange responded that they provide both a paper and electronic version. And of these institutions, 80% indicated that these electronic versions consist of mostly simple scans of the wet ink originals. So this was the result of the survey. And going into the other topic about e-document production, at the Tokyo Forum, reference was made to the increased use of sophisticated platforms for e-document productions, but at the same time, there were concerns raised about the trustworthiness, cost, access, and applicable standards on privilege and confidentiality. Just to add a small footnote, Japan is not a common law system. It's a civil law jurisdiction where discovery does not really take place, but we invited a practitioner based in Tokyo who had extensive experience and practicing in the US. And in contrast, at the LAC event, what was discussed was that it was pointed out that such concerns regarding e-document production were unique to common law systems, and it was also stressed that international arbitration did not have to follow e-discovery practice. So with this brief overview of some of the discussions that took place, I conclude my overview about the project and would like to proceed to the presentations and discussions by the speakers. And in doing so, I would like to stop my screen sharing and allow me to take a moment to ask my colleague technician to put the right screen.
While he's doing that, remember to sort of be a part of the Zoom and whatnot. You need to press the button on the mic in front of you and the camera will follow.
Sorry. So as speaker, we have in last name alphabetical order, Ms. Yas Banifatimi, founding partner of Gaia Banifatimi Shabaya Disputes. Welcome. And we were supposed to have Mr. Harold Epinus, Deputy Director of Institut des études et de la recherche sur le droit et la justice. But unfortunately, due to unforeseen circumstances, he is unable to attend, and he wishes his best regards to all and a successful event. And we have Mr. Lars Market, partner with Nishijimura and Asahi, Mr. Pietro Ortolani joining us online, Professor of Digital Conflict Resolution, Rabu University, Mr. Pierre-Olivier Savoie, founding partner of Savoie Arbitration, Mr. Alexander Wagenheim, head of impact and relations with Gismundi, and we have, for concluding remarks and to share ICC's perspective, Ms. Francesca Hill, head of operations with ICC. And again, many thanks for being with us. So we start with, yes, to discuss. Kicking off discussions on the use of possibly AI in arbitration and other issues surrounding electronic documents. And the stage is yours, yes.
Thank you very much. In international arbitration, there you go. So when you hear the word decision-making, the assumption is that we're going to talk about use of artificial intelligence by arbitrators in the process of their decision-making and the fulfillment of their task. However, if we're looking at AI generally in international arbitration, and I will really focus my comments on international arbitration, you realize that there's other types of decision-making which are made by the parties and counsel and that we need to discuss because this is an important part of AI in international arbitration. So I will address each in turn. First, as regards the use of AI in the parties' decision-making, this is probably the most classic reference to AI in international arbitration. And there's, thinking about this type of use, there's two ways in which artificial intelligence is used in international arbitration. There's first a proven use, an established use in relation to document production, and you referred, Takashi, to e-document production. That's part of it. We may discuss that later. Essentially, AI is a tool that arbitration counsel and parties use in the management of massive amounts of documents. You're all familiar with the number of softwares that exist out there. There's a number of also service providers in that regard. This is the case in particular where a document production is ordered by a tribunal, or where simply looking at a case, if the document is massive, counsel has to deal with that massive documents, a lot of times in millions of documents and pages submitted by an opposing party, or simply retrieved from the client, and how they manage that. So in such cases, what AI does is to help identify relevance. So counsel will identify a number of relevance criteria, will create a sample of relevant documents in that regard, and will ask the machine to detect the relevant documents from the whole batch, which then will be reviewed by counsel so that you can make a discrimination between what's relevant and what's not relevant. That certainly results in time saving and cost efficiency, and that's something that's quite appealing to parties and companies, because it simply is less lawyer time going through documents one by one. Now, as much as it's interesting for time saving and cost saving, it does raise a legal question, this use of AI, which is, where do you stop? What's the threshold? When a party that's requested to produce documents, for example, and resorts to AI tools to gather the documents that will be produced, at what point that party is entitled to stop processing the documents on its own and say, I'm done, I rely on the machine, and these are the documents that are responsive, and my responsibility stops there. And there's a question of an ethical use of AI in this field. So I want to raise the question because these are difficult questions. I've been sometimes confronted with that, so I think it's important to raise it. And even though this proven use is very helpful, again, in terms of time and cost efficiency, the question does arise as to what extent counsel and parties take responsibility for the use of AI, and where does individual responsibilities stop and start and stop. So that's the first proven use of AI by the parties. There's a second use, which is still in infancy, but which is very important, and that is the use of AI in outcome prediction. You will have heard, and this you will have heard in France in particular, in relation to outcome prediction on the actual outcome of a case. But what I'm now going to discuss, because we're not there yet, or we started being there, but it's still in infancy. What we have seen more of is prediction of outcome in appointment of arbitrators, and that is a very important use of AI in arbitration, and I want to say a few words about that. So the use of AI in that regard is to identify, or try to identify, the arbitrator who's perceived as the most likely to render a favorable award for the party making the appointment. So on this basis, for example, in investment arbitration, you want to know who would be the best arbitrator, who will decide best issues of jurisdiction, or if you have an issue of quantum, who will be the most likely to render awards on damages in the sense that you're looking. A few years ago, a startup, Arbilex, had started really focusing on this field and was hoping to achieve exactly that. And they were using massively AI to produce studies that they would then give to law firms and parties to say, based on your question, we've looked at decisions, and this is a list of arbitrators that may be appointed, and based on our study, this is the list of the 3 best that we propose, and of the 3, this one probably is the one you want to appoint. There's a complete delegation to the machine in that regard in relation to arbitrary appointment. And what was interesting, I want to quote what at the time was their motto, and this was not long ago, I'm talking about 2018, 2019, not that long ago. The motto was, I quote, "While the qualitative judgment of experienced lawyers must and will continue to play an important role in the decision-making, an over-reliance on experience in this field has led to unnecessary risk, cost, and error." I found this quote baffling, personally. And they have changed their motto, in fact. This is the motto that they had at the time when they were trying to sell this product, and now they have switched to litigation finance. I'm not picking on Arbilex particularly, but I think it's important that we look at the products that exist out there. So now they have switched to litigation finance, and the motto is that they would use, I quote, "proprietary AI to identify winning cases and connect claim holders with institutional capital to maximize their chance of success." So it's a complete different logic, a different perspective. They have changed now. Their business case is more litigation finance than AI in appointment of arbitrators. Now, I'm using this to show that here we have 2 worlds that collide, and the problems that this raises. First, there are serious challenges to the use of AI in arbiter selection by the parties. The first challenge is that there's a lack of sufficient data. If you look at available awards, mostly these are investment arbitration awards. Most of the known cases, perhaps 500. I don't have, maybe Alexandre will have a better figure than I, but we're talking ballpark 500 awards known out of 1,000 and 1,200 cases that are known. And this is actually something that I will be very interested in hearing from Alexandre about, how we face the challenge of sufficiency of data and balancing out the known cases in investment arbitration with known cases in commercial arbitration. And I know that there's been a big move by Juris Mundi with the help of ICC, actually retrieving awards from the ICC and having more commercial awards, commercial arbitration awards available. Still, we have the issue of how we make sure that there's sufficient representative data out of which we're making decisions. The second challenge is that statistics are skewed and subject to interpretation if no context is provided. For example, the machine can say that an arbitrator has accepted his or her jurisdiction in 75% of the cases. But if you don't know that the reality is that the 75% corresponds to 3 out of 4 cases, you don't have the real picture. So this is what I call the skewed statistic without context, because you don't know that the actual data is very small, and 3 out of 4 is not the same as a much larger batch of data. The next challenge is the existence of biases, and biases are everywhere, of course. And I'm not going to discuss biases in artificial intelligence generally, because there's a lot of debate about that, including gender bias, for that matter. But just again, focusing on arbitration and the biases in arbitration. First of all, how can we generalize based on a handful of awards? Again, that's the point I raised earlier. So that's one challenge. Then how can one determine the views of an arbitrator when he or she was not chair in the tribunal? So if you just have a reference to an arbitrator in a tribunal and the decision was made by that tribunal, how do you know how that arbitrator specifically thinks about the subject sitting on that tribunal? Relatedly, how do you treat dissent opinions? You may have a dissent opinion. Is that dissent opinion taken into account specifically in relation to a specific subject? Just as importantly, how does one determine the relevance of the factual matrix of the case and the complexity of the legal issues determined by the tribunal in each case? So it's not enough to say you have 4 cases or 10 or 20 or 30 if you do not know the difference in all of those cases in the factual matrix. Maybe it was a very straightforward case, maybe it was a very complex case with a very complex set of facts, maybe the legal issues were extremely complex. So how do you determine who wins and who loses on what point. If there's a claim for 2 billion and the end result is an award of 100 million, the defending party may deem that they have won, in fact, because it's a huge decrease in the amount awarded. Is that a win? Is that a loss? So how does the machine determine loss and win in that circumstance? And again, the complexity of the issues and just the assessment of the outcome is extremely complex itself. So these are challenges and biases that go into the machine, and how do we treat those? So that was my first point on the challenges. My second point, and then I will finish on the use of AI by the parties, is going back to Arbilex. I personally think it's arrogant to claim that, as Arbilex did, that it's an over-reliance on experience in this field that leads to unnecessary risk, cost, and error. As we all know, arbitrary appointment, perhaps the most important decision in an arbitration, is an art. It is based on years of experience, developing an intuition and judgment about the manner in which specific arbitrators approach questions of procedure, complex questions of law, evidence, and so on and so forth. It is also based on the understanding of the evolution of the law and the trends, and how individual arbitrators are positioned in those trends, and you have to sit in a dynamic way. The machine in that context cannot be a substitute for that human judgment. It is ultimately a human judgment, an intuitive judgment. It will just give a frozen image in the form of decisions without the context. And so we have to be clear on these challenges and look at how we use AI in that context, not saying that there's an over-reliance on experience, but experience actually is key to how we read the data that we retrieve from the machine. This brings me to the second point, which is the use of AI in arbitrators' decision-making. There are 2 points I want to make here, and again, focusing really on international arbitration. The first point is the importance of distinguishing causality and correlation. As you know, these are two different things, and they should not be confused. Causality is a legal concept, as we know. Correlation, on the other hand, which is what AI does, by treating and ordering data that go one direction or the other. And as we know, legal decision-making requires that the rule be applied to a set of facts through the exercise of causality. Correlation, which is essentially a connection between various situations, which may or may not be a result of coincidence, is not enough for that process. For example, if you say that since the Ukraine war started, arbitrator X has always found in favor of investors, that can be correlation, it's not causality. So the difficulty is how AI and the series of correlations it generates will impact the arbitrator's decision-making, which is based on causality. By saying that, I don't mean to say that the evolution of technology in arbitrators' decision-making is not welcome. Of course, if we look back at the 70s and 80s, databases started making their way into the legal field and made access to data and research much easier, and that was extremely welcome. And we see that evolution still continuing today. In the 90s, when the internet boomed, we saw an acceleration in our ability to do research at a much larger scale. So today's AI and the revolution in that regard takes us to another level with the risk of complex, multiple correlations, which will need to be carefully identified when applying the rule of law in the decision-making. And in passing, and actually this morning, the question was asked by Pierre-Olivier whether I was going to discuss the Colombian judge. I want to put that out on a Colombian judge actually using ChatGPT in the drafting of his decision, which sounds shocking. So the question really is, a judge or an arbitrator, how we use artificial intelligence or the use by the parties of artificial intelligence in the decision-making, in that case, the drafting. But again, and that going back to my point, it is important to distinguish correlation causality, and that the arbitrator's task is to work on causality and the application of a rule of law to the facts, and to do it on his own and potentially draft his own award and his own decision. But I did want to pay tribute to your example, and maybe this is something we can discuss later. The second point I want to make about arbitrators and having distinguished causality and correlation is really the sociological aspects of use of AI by arbitrators and the consequences of use of AI. So AI is now penetrating all fields, as we know, including international arbitration, and this cannot not have an impact on the conduct of the parties, the players generally, parties, arbitrators, and all sorts of players and stakeholders in the field. The impact will be all the more important that there is a belief in the power of the machine. And that is something that we have to be careful about. So I see three consequences and three risks that I want to just list, and I will be done after that. The first risk is the risk of legal conformism and conventionality. As regards the parties' decision-making on the choice of arbitrators, given the parties' entrenched conservatism, as we know it, they will always be more comfortable relying on statistics, no matter how skewed or misinterpreted, rather than taking a chance on a younger, apparently more inexperienced arbitrator. In this sense, AI has the risk of enhancing and consolidating the conservatism of the parties rather than shaking it off. As regards arbitrators and parties' exploitation of data, AI makes predictions about the future based on past situation and hypotheses. At the same time, AI may identify, for a specific situation or hypothesis, a solution that is in the minority or that has gone unnoticed. So there we move from the risk to an actual potential improvement, which is that the minority solutions, which are good solutions, may find a new life, thanks to AI, into the mainstream as potential alternative solutions. The second risk that I see is the risk of over-representation of common law jurisdictions to the detriment of civil law jurisdictions. I feel extremely strongly about this. This is also something that I want to pay tribute to Professor Gaillard, who I had discussed this a lot with. And this was one of his last battles, which I will proudly continue. The world, few may know this, the world is divided between civil law countries, 2/3 in the world, and common law countries, 1/3. But the fact is that common law countries, because of simply the system, because of the fact that case law in the common countries, based on precedents and based on simply the way that the decision is drafted, longer decision, full of citations, self-citations. So that fact will be seized by AI and by the machine in a way that will over-represent those decisions as compared to civil law countries where you have maybe fewer cases or shorter cases or much more concise, and you have actually to understand what they say. You read it 3 times to understand a Court of Cassation in France decision. So that's the risk of that, is that use of AI in the way that parties use it and in the way that arbitrators will use it, if there's a question of comparative law, for example, in an arbitration matter, may have the risk of over-representing the solutions coming from common law countries to the detriment of the solutions from the civil law countries. And of course, they will inevitably have an impact on the outcome of the comparative law analysis, which will be more focused on the outcome and solutions coming from the common law countries. The third risk is the risk of procedures being burdened by new types of disputes. AI has unquestionably resulted in alleviating a large part of the tedious type of work that lawyers do, and that's document review, there's no doubt about it. In the future, the trend may reverse, and we may have new types of disputes over how data is used and interpreted. And I want to take an example, which I know well, which is the UCOS case against Russia. As some of you may know, in the annulment case, which was dismissed, Russia argued that the award had not been drafted by the chair, Mr. Fortier, but had been drafted by Mr. Valasek, who was the secretary to the tribunal. In order to actually show that and prove that, they took an expert who used the machine, AI. I use AI, I put the data in the machine, I take all of the writings of Fortier, put them in the machine, I take all of Valasek's writings, I put them in the machine, I took the other arbitrators as well, and then I watched what's happened. And here's the outcome, and that's what the expert for Russia says to the Dutch courts. If you look at the outcome is that, well, Mr. Valasek, based on AI in the machine, Mr. Valasek has drafted the vast majority of the award, especially the substantive part of the award. And Mr. Fortier has written the procedural history and the facts, which, for those who are, experts in arbitration, know it's a fantasy and it's pretty ludicrous. So then what happens? Is it enough to say this is ludicrous? How can you even consider that Mr. Fortier would write the procedural history and Mr. Valasek would draft the substantive part? Even not discussing the fact that, arbitrators, just as judges, rely on secretaries, and in no way the use of secretaries is a delegation of decision making. But even not discussing that, the problem is that when you have that and you have to fight that argument, you may have to bring your own expert, and your own expert will look at, again, the data. I put the same things in the machine, I put the same data, and I look at the data, I come out with a different solution. So, how do you use the machine? What data have you used? How do you use artificial intelligence? And then you have a battle of experts about how you use data and how you use the artificial intelligence tool. So that actually has the risk of, future disputes over this type of arguments and the treatment of data. So this may mean that simply we're moving also to a new type of disputes within the world of arbitration about simply the use of data and the use of artificial intelligence. I will stop here. I wanted to put all of those out for possible thinking and discussion, and I thank you again for having me here. Thank you.
Thank you, Yas, for the excellent presentation, and I believe that there were very important issues raised and a comprehensive presentation on the AI. And I understand that, Alexander, you may have had a kind invitation to comment on her.
Sure. Well, thank you very much. Is it working? Yes. This excellent tour d'horizon. At two points I noticed that I wanted to comment on. First of all, on the RBLEX switch from one business model to another one. That was very interesting. I wasn't aware of it. And what is interesting is nowadays there are people which are actually doing that, but through human. I'm thinking about Arbitra. This is actually a service that they are now doing. And so this kind of qualitative judgment that was not necessary for RBLEX is actually quite a good business model, at least for them. And this is a service that they are actually providing to law firms to actually make a qualitative assessment of the right arbitrator for a right case, et cetera, et cetera. On the question that you raise on the lack of sufficient awards out there, obviously this is our mission and this is our task. And also, more precisely, the question of sufficient representative data. And I think that the importance is here. Again, diversity is a theme throughout the Paris Arbitration Week, and this is also one of the value at Jus Mundi that we have. Very briefly, the way we do it, and while you were presenting, I just went quickly on our database to see what's the latest figure. We have right now about 1,700 investor states awards and related documents on Jus Mundi. And we have more than 5,000 commercial arbitration awards. So this is obviously the largest collection ever. So it's not that those awards were not there. They were simply just not collected, and they were just simply not disseminated in the way that we're doing it now. How do we face this challenge of sufficiency of data and of awards? Obviously, the first task that we started to do is really to analyze which jurisdiction, after which jurisdiction those awards became public. And we did that around the world, and we realized that actually many jurisdictions release publicly the awards afterwards. And that was the first process that we started to be able to sort of feel this lack of sufficient awards, at least in commercial arbitration, that was partly filled within the investor state arbitration system. The second step, and that was more a step that was taken by institution, and at the forefront of which the ICC has been pioneer in making this movement happening, followed by many other institutions like CAM Milan, I see Stefano here, etc. What happened first is that they decided to publish composition of tribunal, and that will be also very relevant to the conflict of interest and the technology applied to it that I'm going to discuss later. So this already gave a huge insight into the arbitration, at least the composition, at least the human aspect of it. And they've been taking even bolder efforts by deciding to publish full awards. And this is where we've started to partner. Our first partnership was with the ICC, where we actually are able to publish those awards, applying AI and machine learning on those. We pseudonymize and make sure that confidentiality is respected. Those awards are published with full parties agreement under the relevant institutional rules. And this comes the representative data parts that you were mentioning. Yes, it's what we are trying to ensure is that all the jurisdictions have a voice and all the jurisdictions have a say, and all the institutions are represented. And this is why we've been going around the world and showing and sort of educating about the trust that there can be in the technological process about pseudonymizing. And today we have more than 17 partnerships pretty much in all the region around the world. This is again something very important to us, from Africa to APAC to Latin America, obviously US, Europe, of course. And so we're partnering at different levels to publish those composition of tribunals, to publish awards whenever the institution are ready, to make sure that we have representative data from all different parts of the world, not only from Western Europe or United States. And again, we need time from the time that those partnerships are secured and the data are coming, but we are seeing really an increase in availability, and the other part is also to be able to publish them in their own language. So we obviously publish in Chinese, in Arabic, and not only in French or English, etc. So that's the way, at least, we try to address the lack of sufficient data and the lack of sufficient representative data.
Thank you, Alexander, for your input and presenting on your efforts to address some of the risks that were referred to. And I do invite, I would like to invite Francesca. We are fortunate to have you from ICC.
Thank you for the invitation, and thank you to Yaz and to Alexander to be able to follow up. I think the point about the lack of data makes a very sort of carves out an obvious niche for ICC, as we are now heading towards our 27,500th case. So we are sitting on a sheer quantity of case history that, if properly exploited, can of course speak very directly to this lack of data availability, and begs a lot of questions about how we could use it going forward. And I think our challenge is one of scale, actually, as an institution. We're very proud to be in our centenary year and to be collaborating with partners such as Jusmundi to be able to work towards these transparency goals. With a 100-year history, I think the challenge is also that our archiving of our case files looks very much as you would imagine it. It's very different today as it was even a few short years ago. And with the arrival of Case Connect and the ability to have these centralized case records for the first time, it's really changing what we can do. So again, we're extremely proud of what's being achieved under the heading of transparency with Jusmundi. And I think the objective is always to see what we could be doing better and what we could be doing more of in future. So our first challenge is one of scale and making sure that the quantity of not only documents, but also all of the corresponding data that would allow you to contextualize those documents in the context of ICC cases We're looking right now at how we can actually store and manage all of that data and case history and essentially our legacy to be able to keep up with advances in technology that are definitely coming in the next few years. And from a more practice or policy perspective, I think one of the other challenges we're facing is in public fora, such as the events we're seeing this week. There is a clear collective wish to move towards more transparency for such academic purposes. But what we actually see playing out in cases is a definite reluctance at a case level for people to be opting in to having their awards published, we're still seeing by different regions quite a resistance towards the desire to have tribunal names published on the website. So I think ICC also as an institution has a responsibility, and collectively in groups such as this, to answer those questions as to how we can move towards parties and council actually opting in to have in an anonymized form their awards and their case information being put at the service of the public good. Thank you.
Thank you, Thank you, Francesca. And I would have loved to continue on with this fascinating discussion, but I think in the interest of time, we have to maybe proceed to the next topic. But before I do so, I would like to just invite Yas to make some concluding observations, if you wish to, please.
Not really. I think that to be said on maybe just one point on how the use of the data from ICC, because knowing how ICC looks at cases, and the secretariat actually may have data on the complexity of cases, how that will be taken into account when it goes into the machine, so that that becomes the general context of how we're going to interpret the data, not only the award itself, but also all of the context surrounding the case. And I think that there's also data at the ICC, which would be a humongous work, but how that would be retrieved to put back in the context of how we look at the data themselves. Thank you.
Thank you, Yas, and thanks to all the other speakers who have contributed. And now I proceed to the topic of electronic awards, and I have Pietro and would like to invite him to share thoughts on this topic of electronic awards. Pietro, you have the floor.
Thank you so much, Takashi, and thanks for the invitation. It's a huge honor to be here with you, at least digitally, so thank you very much. Maybe a clarification is in order before I start. I will focus on the situation where the tribunal renders an award in digital form only. So I'll focus on digital originals. Not to take away the practical importance of digital courtesy copies, but because the data that Takashi has shown us that resonates with anecdotal experience shows that the practice of a digital original award is by no means non-existent, and Francesca has demonstrated once again how the ICC is a veritable trailblazer in this field, but nevertheless, it is a minoritarian practice. So my question for you today, for our discussion, is how come it's still a minority of tribunals that render a digital award, a digital-only award, so to speak? Are there bottlenecks in the current legal framework of international arbitration? And more importantly, with reference to this panel, what could UNCITRAL do to overcome the obstacles and the bottlenecks? Well, I would say the explanation clearly cannot be that the arbitration community is innovation averse. I think the remarks of Alexandra already demonstrate how innovation enthusiast arbitration practitioners can be, and maybe sometimes we even run too far ahead, as Yas's remarks with regard to RBLX demonstrate. So there might be other reasons, and I will try to go on the hunt for them together with you today, with a specific reference to, of course, UNCITRAL's position. I will divide my remarks in the next 8 minutes or so in two parts. I will look at the digital award at the seat of arbitration, and then at the life of this award outside of the seat of arbitration. Now, starting with the first prong, there are two usual suspects, and those are the requirements for the written form of an arbitration award and the requirements for the signature of an arbitration award. So the first obvious question is, Is that the bottleneck? Is that the obstacle? Well, if we have a comparative look around the world, many lex arbitri, many laws, arbitration statutes around the world do not expressly provide that a digital award complies with written form requirements. And that is, for example, the case for Article 31 of the model law. There are exceptions like Dutch law. I'm currently based in the Netherlands, and the Dutch Code of Civil Procedure expressly provides for that. My question is that a problem if the law of the CIT does not contain an express arbitration-specific exception? And my answer would be typically no, in the sense that even in the absence of an arbitration-specific provision, there might well be, and there will often be, a general provision that ensures that a digital award has the equivalent effect of a paper-based original. By the way, that is also the case for the model law. Article 31 of the model law does not provide anything with respect to digital awards, but the model law on arbitration shouldn't be read in isolation. It should be read in light of its international character under Article 2A of the model law. And that means, of course, also in light of the model law on electronic commerce. And Article 6 of the model law on electronic commerce essentially gives us the reassurance we need. So I would say, in and of itself, even in the absence of an arbitration-specific provision in the law, the CIT, that is not enough to conclude that a digital original does not comply with written form requirements. Very, very often it will comply with written form requirements. And I would say the same analysis or a similar analysis applies to signature requirements. Once again, the Dutch are very explicit and they put it right in their Code of Civil Procedure. But even in jurisdictions where such a specific provision does not exist, there might be a general provision that allows arbitrators to sign an award digitally and ensures that, for example, a qualified electronic signature has the same effect as a wet signature. That is Article 25, paragraph 2 of the EIDAS regulation in the European Union, just to make an example. So if those are not the bottlenecks, then at the seat of arbitration, the question comes, how come there are so few or relatively few awards issued in electronic format only? And I think we need a reality check, and it's a bit of a humbling question to ask, but assuming that there is a digital original award, the uncomfortable questions are, what can the parties do with it? For example, can the award creditors serve the award digitally? Can the parties produce the award in setting aside proceedings digitally? Can the award be produced digitally in the context of enforcement proceedings? Can the award be used as a title in the filing of a notice in a land registry or in a registry of security rights? And if the answer to all of those questions is no, and very often it will be no, unfortunately, depending on national law, then the question is, what is the added value of digitalization if you need to go through paper for all of those purposes? Now, tribunals might not see that added value for good reasons, I would say, and they might be reluctant to avoid paper when paper makes the award more easily enforceable. And of course, understandably, tribunals, institutions, and parties care about frictionless, as much as possible, enforceability. And that is probably one of the reasons why, for example, the SIARB guidance note on remote proceedings says, and I quote, that it's advisable for a tribunal to render a paper-based original. That is one of the exceptions to the general digitalization of arbitration proceedings that Takashi was mentioning in the beginning. So from that point of view, I think the position of UNCITRAL is not the easiest one, because those bottlenecks often will not be arbitration specific. And it is not something that you can necessarily fix by reviewing the model law, for example, because they are something that have to do with, for example, how a public registry works, or about how national civil procedure works outside of arbitration, or, for example, how a bailiff works. So it's a very ambitious digitalization challenge ahead of us. But for the position of UNCITRAL, the second prong of my analysis is maybe more promising and interesting, and that is, what can you do with the award outside of the seat of arbitration? And of course, to be more specific, the focus here will of course be, for the time being, on the New York Convention. I will not really spend any time, in the interest of time, on Article 1, Paragraph 1 of the New York Convention. There have been in the literature some voices that argue that there might be a doubt as to whether a digital original can qualify as an arbitration award at all for New York Convention purposes. I think this is mainly an academic concern. First of all, because Article 1 does not contain grounds for refusal, so we should not stretch it to refuse recognition and enforcement in any way. But most of all, if you look at the cases where in practice courts have disagreed as to whether something counts as an award or not, irrespective of whether that is an autonomous notion or not, which is a thorny issue, admittedly, but those are all cases that have to do with the content of the decision, or the relief granted by the tribunal. For example, a court that says, well, it might say award, but to me that is a provisional measure and it doesn't count as an award. Those are not cases that have to do with the form of the decision. So when it comes to form, I think the main suspect, and it's something that Takashi already mentioned in the introduction, is Article 4, Paragraph 1. If we read Article 4, Paragraph 1 and the evidentiary requirement, once again, not a ground for refusal, but an evidentiary requirement for the award creditor to produce a duly authenticated original award or a duly certified copy thereof, well, of course, at the time the provision was written, people had in mind a paper-based award. And to be sure, I am not arguing that we should apply the New York Convention in 2023 in the same way as it would have been applied in the 50s. I am by no means an originalist, and by the way, that is not how you should apply a treaty. But of course, understandably, when tribunals and in general arbitration actors think about enforceability, they do prepare for bad weather. So the question is, what is the worst, possibly worst, or at least arbitration-friendly interpretation of Article 4, Paragraph 1? And in that sense, it is that you need a paper document, either a paper original or a paper copy. And the question is complicated by the fact that you need to find the law applicable to authentication, which in and of itself is a challenge. And that law might once again require you to go through a paper copy of a digital original, for example, which in turn largely takes away the benefit of having a digital original as opposed to a digital courtesy copy of a paper-based original. So, in other words, the Article 4, Paragraph 1 of the New York Convention does show its age a little bit, even though, of course, an evolutionary digital-friendly interpretation is absolutely commendable and preferable. And there might be also some grounds for refusal that might sometimes be relevant. For example, in a case where the parties have chosen a set of rules that requires a paper original, arguably Article 34 of the Swiss rules does that, then a failure to provide a paper original, of course, might be a ground for refusal under Article 5.1d. And of course, inexistence or invalidity of the award at the seat may be a ground for refusal under Article 5.1e. So that is maybe one of the reasons why the arbitration community is very cautious when it comes to digital originals. And the question for UNCITRAL is, should something be done about it, and what should be done about it? Now, when I look at the model law, I think there's not so much left to do, in the sense that the model law already, when read in connection with the model law on electronic commerce, does essentially allow electronic originals. There might be a point in confirming that that is the case in the model law on international arbitration, mainly for enacting states that are not also enacting states of the model law on electronic commerce. And secondly, as a signaling device, right, to make things very easy and clear for all tribunals and parties. Apart from that, Article 35, Paragraph 2, which mirrors Article 4.1 of the New York Convention, already deleted the need for authentication or for an official copy. So from that point of view, I think at the level of more favorable treatment under national law, the model law has done what it could do largely, apart from the need for an arbitration-specific reassurance that digital originals are possible. Beyond that, could something be done at the level of international law? That is an open question that I want to put to the floor, and I'll conclude on this point. I don't want to scare you. I won't even touch upon the reform or revision of the New York Convention, because I think there's no appetite for that for very good reasons. The real question is whether there could be an additional treaty, a complementary treaty, if you will, at the very least, obliging the contracting states to afford a more friendly evidentiary treatment for the award creditor as compared to the one afforded by Article 4, Paragraph 1 of the New York Convention. So basically, essentially an elevation of Article 35, Paragraph 2 of the model law to the level of international law with specific reference to digital originals. That is admittedly a very modest goal, but maybe more achievable than the more ambitious ones, such as, for example, the hashification and blockchain verification of awards that have been fantasized about in recent years. And that is, I think, an open question for all of us and for UNCITRAL. With this, I conclude my remarks, and I thank you very much once again for having me.
Thank you so much, Pietro, for your excellent presentation and your observations in a very structured manner. And I already have a request for the floor and comments from Lars, so please.
Thank you very much. I'll just have two brief comments. And the first one is, in a way, I fully agree with Pietro. The issue that we don't have digital awards is not so much a reluctance to innovate, but it's really a risk aversity on the part of tribunals and counsel. I would, as an arbitrator, I would love to not have to chase my co-arbitrators for signatures and set up the process and then wait for a week until I have everything collected. But that's the way it is. Like, you don't want to be set aside, or you don't want to have the award not enforced because of an issue. And if I'm a counsel and my colleagues come back and say, well, we actually don't know whether this is valid or creates a problem, and then it's clear, like, we end up with a paper copy. The second practical point I wanted to make is, when it comes to electronic signatures or digital signatures, I think digital signatures is the interesting thing. Even if you were able to comply with the requirements, and probably those of the seat of the arbitration, the reality is that very often none of the three arbitrators actually are at the seat of the arbitration, and you would have whatever the seat requires, a little digital box with a little card so the seat, the law under the seat accepts this as a valid digital signature, and none of the three arbitrators have those, and also they're not prepared to get those, to comply with the requirements for a proper digital signature of a completely different country. And again, I feel that is a practical issue. So I think there's a lot of work for UNCITRAL to do, a lot of thought to be put in.
Thank you, Lars. And now I invite Pierre-Olivier.
Thank you, Takashi, and thank you, Pietro, for the excellent presentation. I just wanted to jump on one point, which is the link to the enforcement laws, which I think is very important. I have some enforcement practice in France. Others have much more than I do, but I have enough to know that if you show up at the registrar, show up to go see the registrar of who's responsible for the registration of the execution of international awards at the judicial tribunal in Paris, and you bring her an electronic award without an original signature, you will have question marks in her eyes. She will give you her little note that she gives all the lawyers who don't bring enough copies of originals. And I see people laughing in the room. Some people may have gone back to their offices to get more copies and, have, interactions with the registry in terms, I would be very interested to know if anyone has ever successfully, recognized a digital award in France from the little practice that I have, I would be surprised, but perhaps not. But I think it also goes to something that I've mentioned in previous discussions with Takashi, which is I think that enforcement laws are very important to this project, so that you can understand the various aspects of arbitration and how they kind of interact with how the award will be recognized and enforced in the domestic jurisdictions, and without knowing the details, which probably change from one jurisdiction to another, you won't necessarily understand the full implications of what you're doing. And I think that the example of the electronic award is a very interesting one.
Thank you, Pierre-Olivier, for making the additional points, and our discussion on the matter will continue. So now I proceed to the next topic. I have Alexander to present on Jusmundi's conflict checker. Please.
Thank you so much, Takashi. Thanks to UNCITRAL and thanks to Sciences Po for having us. So I will discuss the impact of technology on the issue of conflict of interest and disclosure. I think it was particularly fitting as the DRDE project aims to monitor the changing landscape and the disruptive aspect and also the enabling aspect of it. And I think a tool such as the conflict checker that we've created is disruptive in the sense that it changes the way we're conducting research on conflict of interest, but it's also enabling because it really is cost efficient, and we're seeing more and more in-house counsel using those kind of tools as a preliminary step before handing over to lawyers and also having a say and actually helping on the decision and the selection process. So obviously, users consider independence and impartiality as one of the key element, an indispensable element for fair arbitration, and obviously trust in a neutral panel to address carefully and review the dispute and adjudicate the dispute is obviously the arbitration raison d'être. One of the key reasons we select arbitration is also to avoid this sort of so-called home court advantage, and so the neutrality is obviously a part of the selection of arbitration. Now, user expects that we do pay a careful attention on potential conflict of interest, and it is if you're missing a conflict because you have a faulty database, that's an issue, especially when it's discovered later. Now, user, of course, expects arbitrators to be full and frank in their disclosure. Now, the trends I'm going to discuss is really through Jusmundi's experience, how the use of technology is slowly reshaping that issue. Quickly, for those of you who don't know Jusmundi, we are a search engine and a database created in 2019. And our mission is really to promote the rule of law and global justice as a whole. And we do so by making legal documents accessible worldwide and legal professional visible. While I'm talking, hopefully it will appear at some point. I don't know why it's, hold on, let me try. I will try to hopefully make you some live example, which may be a little bit more entertaining than my very old law knowledge. So what, why did we create that tool? First of all, one of the many evolution in our database was a search functionality that we created. We created actually a party and arbitrator filter, which I can show you right now. And what we realized actually that parties were using that filter to make conflict check. So I can give you a quick example. For example, if I'm taking a lawyer here, very randomly, I know a friend of mine is in the audience, so I'm just taking her as my use case. So Diora Zeyeva, for example, she's a partner in Dentons in New York, and so parties usually were using those filters to find relationships. So while I'm clicking here, I can see all the arbitrator that she has been appearing in front of. And so, for example, if I want to see in which case she has been appearing in front of Philippe Sands, I just click both DIORA on the parties filter and on the lawyer filter and the arbitrator, and I can see all the cases in which DIORA has appeared before Philippe Sands. So that was the first part of the construction of our conflict checker. We realized, and we had feedback from users, that they were actually using those filters to try to make relationship between parties and arbitrator, etc. In between that moment and the building of the conflict checker, what happened is what we discussed earlier. What happened is institutions starting to share composition of tribunal. What happened is institutions starting to partner and have full awards, anonymized, etc. And so as of today, we have the large collection of arbitral award, but also mostly important, all the case information that we have been able to collect on public sources around the world. And with that, we decided at one of our brainstorm sessions that it was perhaps time to create something a little bit more deep with the real intention of being able to spot different relationship. So what the search engine was enabling us to do was to see direct relationship of people actually appearing in the same case as we just see with, for example, with DIORA and Philippe Sands. But we didn't have the ability to find indirect relationship that might occur with, within the arbitration community and participants. So how did we conceive the conflict checker? So we had to address two questions. The first question we had to address was a legal question. What are we going to consider a relation? So if we look at, obviously, the IBA guidelines, we have the objective approach that any circumstance that may be disclosed in the eyes of any reasonable third party, or we have the subjective approach, which is that circumstances may be important and evident in the eyes of the party, and would give rise to a justifiable, reasonable doubt as to the arbitrator's impartiality and independence. So those two are the legal kind of criteria so far in terms of disclosing. We decided on purpose that it was not for us to enter that debate, and we decided that we would step out of the question of the legal meaning of a relationship or not. So we stepped out from that, and what we are seeking to do is just to give objective data as to relation. And so we give those objective data, and arbitrator and counsel will just select those that they deem relevant. An arbitrator will select those data that it deems relevant for its own disclosure. Counsel and in-house will find in the conflict checker a very powerful due diligence tool when selecting an arbitrator, or even later to verify whether the arbitrator has discharged properly its duty of disclosure. Again, I think, and that's, we can make an analogy with what Yas was saying earlier, and that's, for example, the difference that she was mentioning between causality and correlation. Again, here there is a difference between conflict and relation. We're not saying that what we are providing are conflict, we're just saying that they are relation, and what the machine is doing with our artificial intelligence and the algorithm that we've been building are just making link. They're not saying this is a conflict or not. And again, this is where a lawyer still remain indispensable. Now, the second question we had to address in building that tool was a tech question. How do you code relation? How do you explain to a computer which relation, what is the different type of relation, etc.? That was a very tricky question. And it took us some time, but technically we created a specific database for that, which is called a graph database, and basically all the social networks are kind of based on those databases, which actually, for example, on the search engine, the structure, we index people by their profession, etc. on our main database. On this one, we index people through their relationship, and that's how we are able to connect people among them. Quick example to show you. So you'll see on the product, you have here the conflict checker. So I'm going to make a very quick example with somebody that we all know, who was our keynote speaker this week. So if I'm taking Yas and I want to see, for example, I want to appoint Yas in a case and the opposing party has already appointed Gabriel Kaufman-Kohler. So I want to see what kind of relationship there has been between Yas and Gabriel, and I want to see whether she's a suitable candidate. The conflict checker allows you basically to either see relationship between individuals, a relationship between individual and firms, relationship between individual and states. So here I see, for example, recorded occurrence where I can see from the description that Yas was counsel for a party and Gabriel Kaufman-Kohler was president in the case. And these are cases which are reported on Newsmundi. Of course, by no means they are all the cases, but at least these are the publicly available cases that we have. And these are direct relationship. If I look at indirect relationship, I have many different type of relationship, which of course will need to be assessed. But for example, if I'll take the first case, I know that Gabriel Kaufman-Kohler was an arbitrator and David Ernst was a counsel for the claimant. And I know Yas and David at some point worked at Sherman and Sterling. Is this sufficiently a conflict or not? Probably not. But this is, again, we're just giving kind of relationship between firms, et cetera, et cetera. Second example, in one case, I can see that Yas was counsel for respondent, Schallenberg was the opposing counsel. The conflict checker allows me to see that Gabriel Kaufman-Kohler at some point worked for Schallenberg and Wittmer, et cetera, et cetera. This is the sense of indirect relationship. And again, there is, it is for the parties then to assess which kind of relationship might give rise to justifiable doubts or not. If I'll just take another example, I want to point Yas, and in front of me I have the team from Squire Patent Bugs. I can do that. I want to see what kind of relationship. Well, I can see that, for example, in one case, Yas was counsel for the claimant and Squire was in front counsel for the respondent. Again, I can go and look for indirect relationship. I can do the same with states, for example, Egypt. Very random choice. I want to appoint Yas in a case where Egypt, so most likely she will be representing Egypt, but in any case, what the conflict checker is saying is that she has been representing Egypt in a number of exit cases. And so at least I have, in a very quick way, all the relationship and all the occurrences and all the cases in which I can easily verify that. And again, I can have indirect relationship. Again, so this is a very, and we can, that can be a little bit more refined. We can have secretary, we can use expert, et cetera, et cetera. That was a very sort of a basic overview, but this can be used in a very much more refined way and in a granularity that allows, and we've seen, and we had a lot of feedbacks that have allowed people to actually spot before going to arbitration some very potential disturbing conflict of interest. Now, how does the conflict checker answer the needs of the arbitration? So we've seen, and we've discussed it already, there is a lack of information on prospective arbitrators. And we were before those tools relying on sort of some arcane reliance on bits and pieces of information here and there on people, and that was clearly a drawback. And we've been witnessing, and again, thanks to a pioneer institution such as the ICC, the CAM Milan, who have decided to actually publish the composition of tribunal. VIAC also has followed suit, and many other institutions now in Latin America are also publishing composition of tribunal. Those data are fueling the conflict checker. Those data allow us to see who is sitting with whom, who is appearing in front of whom, et cetera, allowing for a much more systematic actually approach to those relations. Another problem that we've seen and how we see the conflict checker is addressing those issues is really that even the sophisticated traffic light system that we have in the IBA, or even you know, a little bit more robust approach taken by the ICC, they do not capture all the various type of relationship as the indirect relationship are trying to capture, and this is where we believe there is a need that is answered. And again, another point, and we're discussing a lot about double heading, especially at UNCITRAL right now. Again, the conflict checker is really allowing you to see when a person has been sitting in a case or as a counsel or has been deciding an issue in such a way or has been advocating that issue in another way, etc. Again, this is a need that we think is answering. I will conclude with a preliminary assessment of the conflict checker and the criticism that have been raised. So it is now a great success, and we are seeing a growing percentage of our users actually subscribing to Usemundi, not really for the database, but for due diligence tools such as the conflict checker. More and more in-house counsel, governments are using Usemundi and its conflict checker to actually do those due diligence aspects. So to be fair, we did not really anticipate that success because, as I said, that was an idea that we had in one of our little brainstorm session because we saw the usage of the filters and we decided, okay, let's do this. But of course, with some success come obviously some critiques. And the first critiques that I've heard was that the conflict checker has the effect on arbitrators of over-disclosing. Now, the issue is not new, of course, and that existed before we created that technological tool. But of course, the argument is here more that it exacerbates that. I mean, I would not probably enter to that debate, but I think the IBA has tried to address those concerns about over-disclosing by having the green list, etc., of things that actually do not need to be disclosed. The second argument that I've heard is that it allows frivolous objection and that sort of challenge on a sort of US-style broad blanket approach where you throw everything and the arbitrator has to sort of justify everything again. And I had a very concrete example. I was at ICA last year and an arbitrator came to me, huge fan of Usemundi, saying, oh, that's great, everything that you do, but I have an issue with the conflict checker. I have an issue, the algorithm doesn't work well, and she explained me the following scenario, that she was in a case, she was appointed but not confirmed yet, and that one of the parties threw out all this indirect, manifestly not relevant relationship from the conflict checker, and that she was forced to reply to each and one of them, and in the end the institution decided not to confirm her because the party has made too much fuss about her appointment, and so she was not confirmed, and she was taking issue because of the conflict checker. So I was, I mean, this can obviously happen. To be frank, in my practice, I've seen a number of arbitrators resigning and withdrawing before even getting to any confirmation because they were obviously doubts put into question. As a personal view, I think, of course, it's always better to take a long-term view and err more on the side of disclosure and then perhaps risking to lose the confidence of the parties or even worse, the award at some point. But when I first made that presentation, I was in Africa and I was in a room full of African qualified lawyers and arbitrators, and I didn't feel sorry for that arbitrator because obviously, yes, it was a pity that she was not appointed, but there are so many arbitrators around the world that can be appointed in that particular case. I think another parallel, and I will conclude here, that we can make on that, and obviously technology is what you made out of it. You can use it to disrupt proceedings, but you can mostly use it to make arbitration more accessible and more diverse, and this is what we strive to do at Usemundi. I think it's really for the system to try to find a way to resist those kind of disruptive attempt at throwing all those data. We've seen that with disclosure of document. I think the system has tried to find ways to actually canalize those overly requests. At least when I was a lawyer, we find ways to, with reference schedule, etc. And the same thing will apply. And again, technology is what you made out of it, and I think. It has been proved very useful and very successful, but obviously we hear that it can have some disruptive effect to a sense. Lastly, perhaps we are considering some improvement on that. Perhaps what we heard is that a time limit might be interesting to be put on the conflict checker, for example, notably to respect the 3 years period that are provided in the IBA guidelines, for example. And so this is something we're working on, but obviously we welcome any feedbacks on making this, because we are building that. It's built by lawyers for lawyers, so whatever we can to improve this, but so far we believe it satisfies at least the needs that have been identified. So thank you very much for that.
Thank you, Alexander, for a comprehensive presentation about the system that the service that you provide. And it's one of the types of systems that we would, as UNCITRAL, would like to learn more about. So I hope that our collaboration would continue. And yes, and I believe that, so there is one participant, Stefan.
Yes, Stefan Azzali from Milano. Alex, I don't believe that you should limit in some way the collection of data, because frivolous challenges, they will be there anyhow. I've been challenged because I played football in a match 12 years before at the ICA conference in Rio with the council that after 12 years appointed me as an arbitrator. 12 years after, playing football, rest of the world versus Brazil. We lost it, by the way. I know, that was the sad story. 12 years after, I've been challenged. Well, actually, I was not challenged, but the award has been challenged before in Paris, and of course dismissed the challenge but I've been accused not to have fully disclosed. I mean, you should collect also all the football game I played in your. So I think that a role should be played honestly by arbitral institution. And I would, in the case that you mentioned, I would blame on the institution that did not confirm that arbitrator only because the parties were, just complaining. Okay, if you have a grounded challenge, then the institution should replace. Otherwise, you can use 15 grounds, if they're not serious, they are frivolous, the institution should reject. And that's at least what we are doing with other institutions. So I think keep on collecting data. That's I think it's a good approach. If you keep on taking off my microphone, I will be disappointed. So we have to increase trust. So keep on doing it.
Thank you. The idea is not to just to limit, but the idea is to give the option to parties if they want to restrain to a time frame to be able to do so. But obviously, the data will continue to be available for and accessible for any time range. But yeah.
And I have yes, please.
On the time limit, and with the ICC, I remember that years ago the decision was made to actually be much broader in terms of the time span, go beyond 3 years and go back even 10 years if needed, because you want to be quite complete and exhaustive when you could look at conflicts, and that's very good because it's it helps the process. My question goes to, and it's a sort of flip coin of what Stefano just said, which is I didn't have time to really look at when you were showing the indirect relations. My question goes to how far do you go in what you characterize as a relation? I think from what I saw, it's essentially positions of counsel and arbitrator, and that's it. And then the machine makes the connection between the two. It may be complete or incomplete based on the data that you have, but how far do you go? I mean, yes, the football playing, that's a good example. But we've all seen other examples of sort of other types of relations. I remember years ago in London there was a conference, and this gentleman from Russia mentioned that under Russian law it can be a conflict to be sitting at a conference with someone, just meeting them at a conference, and you can be challenged for that, right? So how far do you go? Do you actually include in the data conferences? Because that's endless. Do you include co-authorship? I've been in situations where it's IBA green, but you may be teaching in a university, somebody else teaches in the same university. Would there be a conflict between Diego and me? If, for example, I'm invited to teach in this house, and so on. So how far do you go to create a relation. That's first question number one. And related to that, and that I go back to the problem that I raised in terms of AI sort of enhances and consolidates its conduct or changes conduct, right? If we have more data and the data is more diverse, then it can change the conduct of people, you know. And we see arbitrators, Stefano, you're quite relaxed about this, but I've seen arbitrators who are not relaxed. They're extremely concerned and scared. They will not talk to you at a conference. They will not say hello at a conference. They don't want to be taken in pictures because they fear challenges. And so as a result, you don't have a social life anymore. You don't go to conferences. You don't write articles with anyone. You don't teach anymore. So, and the end result is that you will have, you know, newcomers all the time if you want to avoid conflict, which is nonsensical, right? So the problem is that this has an impact on how we conduct ourselves in the field, in the community, because it is a community. So how far do we go in creating those relationships, characterizing those relationships, bringing them into the machine as a data that will be taken into account without it becoming an impediment to how I behave ourselves in a normal fashion in our community? I mean, that's my question for you.
Thank you. That's almost an existential question, the second one. But I think how far we've got. You summarized it very well. We've got we did connection through positions, secretary, council, etc. Position in firms. So you've seen the example of Gabrielle Kaufman-Koller. I could go down. She was at Baker. She was at Schellenberg. She is now at Levy Kaufman-Koller. And so all of those movements are recorded. And so this allows us to see, okay, you had a case with Baker and McKenzie. Watch out. She was a partner at Baker and McKenzie. So this is a connection, and you do whatever. So this is as far as we've got. We've entered publication with the ICC Dispute Resolution Library, and more publication to come on Jus Mundi, and that's a question we were wondering. Should we include authorships? Should we, as a relationship? Obviously, as you mentioned, these are part of the green list of the IBA rules, but should we nonetheless include those? When I raised that in a conference, people were not happy at all. And I say, well, I'm not entering into that debate but this is a real question, and you were right to mention it. I mean, obviously, we need to strike the right balance, of course, to be able to live in a civilized world where we can all greet each other and be at conferences without being scared of being conflicted or etc. And this is again the excessiveness and the. Again, going to my point is technology is what you make of it, and how you use it, and again, I think the system has found great ways to use it in the right way and an efficient way. Again, I don't think we are happy to contribute our part on that. And we build those tools by having feedbacks from user, etc. That's why we haven't gone that far to include publication, but we might. That's why we are considering that in some cases people need a tool to just adjust that to a time limit, etc., etc. But I agree with you, and on the more elevated question about what kind of and this is why I wanted to discuss that today, because it does have an effect on how we approach the issue of conflict of disclosure. And we've seen many arbitrators are not on LinkedIn. You can't post a picture of them on LinkedIn, etc., etc.
Sorry to take the floor again. One question, Alex. Do you take record of the time, the day when the request has been filed to conflict checker? Just to explain, I think that the duty to investigate should be discussed. When a party should use the conflict checker? When they lose the case, as it happened with my football match, or at the beginning, when I've been appointed. I would say the first. I mean, when I'm appointed, you have access to the conflict checker, use it. Then, if there is something wrong, raise it, not at the end. Is there any way for you to keep record of the time when it has been requested? That would be fantastic.
we're seeing different use of it, of course. Obviously, we don't track people on their usages, and these are all anonymous data for data privacy concerns. But what we're seeing is, of course, they're used in both ways. They're used in and before for the selection process and after to challenge. And we've seen you can see on Jusmundi if you actually make a research of ourselves, so Jusmundi, and you will see that we are quoted in two challenges. One was made against Brigitte Stern, and one was made against Larry Shore. And also, that's a new implication because those data are now on Jusmundi and those are considered public. Then both challenges failed because those data were publicly available on Jusmundi, and so they were supposed to be known by the parties, or at least should have known, etc. So there is also, a positive aspect on that is that it's broadened the availability of data and make sure that more data are publicly available, and so challenges may not be that easily successful.
Thank you, Alexander. And just so that the following speakers know, as in football, I have sought for additional time by my fellow co-organizers, so I hope you won't feel too pressed with time. And with that, I would also like to pass the floor to Hector, who has requested. Please.
Thank you, Takashi. This is Hector Flores from Mexico. I want to go back briefly to Yas' existential question regarding how these tools and information may modify the way we behave ourselves towards arbitration. And I'm probably going to state the obvious, but I wanted to share that my concern is sometimes I think we need to go back to the basics, or at least make sure we are able to distinguish what is relevant and what is irrelevant. The abundance of data may be, or let me say this differently. It may be useful sometimes to see the abundance of data and information with some degree of skepticism, and not because it doesn't mean, or not because it's not relevant in itself or it's not useful, but sometimes it can throw us off from what is relevant. Sorry to go back to that word again, but to put this as an example, there should be, in my opinion, some responsibility on the product providers regarding how they present their products and what they are supposed to do, or how they are supposed to help us to appoint an arbitrator or to determine whether there's a conflict of interest per se. But also there's some degree of responsibility on the stakeholders, and that including the institutions. Going back to what Stefano said, it should be, there should be a point in time when it is irrelevant how much data do we collect, and what is really relevant is what is the actual decision taken by the arbitrator when he or she decides to disclose some information, and by the institution or the court whether they uphold a challenge to that arbitrator. That part of the decisions should be made based on categories and concepts that we've known for quite a few years in arbitration, regardless, again, of the abundance of data. So this is probably very obvious, but I just wanted to put it out there, and thank everyone here today for posing so many interesting questions. Thank you.
Thank you, Hector, for your contribution. With that, maybe we can conclude this topic. And okay, Eric, you have like.
Good morning, and thank you, Alexander, for the presentation. I have to admit, from an institutional perspective, from HKIC, I would be, I'm a little bit concerned about the tool. And this is because from an institutional perspective, one of the primary things that we are looking at in terms of use of technology is a method of making proceedings more efficient, making them cheaper, making them with the user in mind, of allowing them to go through the arbitral process with increased time and cost efficiency. Now, one of the most time-consuming elements for parties who and counsel who know the arbitral process is challenges to arbitrators. Regardless of whether or not a challenge will be successful or not, it affects the time that a dispute can be resolved, right? There are many times that the institution, HKIC, I'm sure other chambers and other institutions have seen this as well, where the point of the challenge is not so much to get the arbitrator off the panel as it is to delay proceedings, to make sure that something is there that the institution has to deal with, that the arbitrators have to deal with, that basically extend the length of proceedings. Usually, it's on the basis of the respondent, right, who wants to delay the effect of the award. Now, the use of the conflict checker, I understand the purpose of it, I understand the means of it, but I'm not sure that all of these relationships basically create issues of conflict. And as you've noted, the tool itself does not propose to show issues of conflict. But what it does do is it provides a tool for parties who may be wishing to engage in guerrilla tactics, who may be wishing to act in bad faith, who may be wishing to act to delay proceedings, to find ammunition in relation to potential challenges. And that is something which, you know, then the institution has to deal with in terms of increased costs, increased time, increased administrative efforts that arbitrators have to deal with. And it also creates, as others have mentioned, a chilling effect in relation to arbitrators who either are unwilling to participate in events such as this at Paris Arbitration Week, where you have 145, 152 events, all of which will eventually show up in a conflict checker, in which a party who may not necessarily be acting in good faith will use to derail proceedings. And I'm not sure there's been enough thought given into the effect this will have in relation to challenges. I think you've just mentioned two challenges that were made against tribunals that ultimately failed. Yes, they may have failed, but would those challenges have been filed in the first place had conflict checker not been there? And I think that is a question that has to be dealt with. Thank you.
Thank you, Eric. And I think it's fair to give Alexander a chance to respond.
Thank you, Takashi. I understand your concern. First of all, we do not include conferences in the conflict checker, so no issue there, nor events, nor all of that. As I said, we limit ourselves to position of parties, arbitrators, secretaries, and position within cases. And so I think it's fair to say that we are on the safe side here, and this is just putting connections that were made on a very sort of artisanal way before and which are just made quicker. And I think perhaps, while I understand the concern, I think the major point of creating that is to allow parties to find the right arbitrator for their case. That's the main purpose of also the conflict checker. It allows you to make sure that the person that you're going to appoint is free from a relationship, etc. So I think, you know, we shouldn't forget the real purpose of it. And of course, it can be used as guerrilla tactics. But I mean, this is part of the process, and that existed before the conflict checker, and it might exacerbate it, as I mentioned. But I believe it answers more needs than it creates problem.
Thank you, Alexander, and thanks again for the great presentation and for all the contributions from around the table. And now I would like to proceed to the next topic, which will be presented by Lars on case management, please.
Thank you very much, Takashi. So I'm going to speak about case management, and of course, with a view to the UNCITRAL's project. So in a sense, I want to address two main aspects. So the enabling aspects, as we've seen in Takashi's slides, when it comes to costs and duration, and the disruptive aspects of due process and fairness. And I think I'll conclude with a third aspect, which wasn't on your slide, which is, I call it the preservation aspect. So the saving of resources, being environmentally friendly, which kind of overlaps in a certain sense. In terms of conceptually approaching the issue of case management, there are different players. So you have the arbitral institutions that are quite active when it comes to that. They put out case management platforms, they put out guidelines or commission reports. So that's nothing I'm going to address. Then we have the private solution providers like Jusmundi, there's Opus 2 that provides a platform for hearings, Exhibit Manager that allows you to take care of exhibits in an electronic form. So I'm also not going to address that. I'm going to approach the issue more from the viewpoint of arbitral tribunal or council. And conceptually, again, I think one thing we need to distinguish when we talk about case management, there is the issue that Jas mentioned, the usual discussion centers around civil law versus common law and which one do you prefer. I'm happy to invite you to Asia so we can promote the civil law approach a bit more. But today I'm more focusing on kind of the digital aspects of case management. To conclude on the conceptual framework, I think what's really important to be kept in mind is that not every arbitration is the same, and not all arbitration practitioners are the same. So I would say that there's a lot of firms in Paris that focus on really, really big arbitrations with where there's a lot of resources to handle those arbitrations. If you now go to my region in Asia, it can be very different. So there's much smaller cases, and you'd approach them very differently. So I think that's something when we talk about case management, we have to keep in mind that not every case management can be the same, and not every case management proposal is appropriate for everything. And it is particularly important when it comes to digital solutions. In terms of now talking about the enabling aspect, I think you said, well, one of the issues the UNCITRAL has to deal with is information overflow. And in a sense, that's kind of the reactive aspect to a problem that we face in arbitrations. The proactive aspect is how do we use technology to make things more efficient. And of course, talking about the enabling aspect, I think there's a couple of obvious case management tools. I mean, by now it's standard to have digital submissions. You transfer your files normally, or quite often at least now, via FTP links. So you have a strong move away from paper copies, which of course is great, and again also for saving the environment, saving the trees, shipping costs, you save time. So that's one of the easier aspects. I think the one big aspect that has also become quite normal, so the one upshot of the pandemic is virtual hearings. And it's often discussed as a big cost-saving tool. Actually, when I look at it in my practice, the couple of nights in a hotel you save are, in my view, not the large cost-saving aspect. If you have a 2-week hearing and the lawyers have turning on their clocks for the billables, the cost you save by not going to a hotel is, in the end, is 5% of the total bill. So that for me is not the main aspect. For me, the real advantage of having virtual hearings is improved case management. So you can meet more often, you can meet more easily, not necessarily for the evidentiary hearing, but suddenly you now can put in your timetable a lot of other hearings. So the case managed conference is much easier now, but I think it incentivizes arbitrators to use different kinds of hearings. So the midstream conference that sometimes you meet with the parties after the first round of submissions, give them guidance for the second round of submissions. You might, as a tribunal, meet with the parties before a document production kicks off. So I think that's the real advantage, less so the cost saving. And then, of course, what we're going to see is case management platforms. I think that's a really exciting development, which is kind of only now coming. And that, I think, will, in the end, define the competition between arbitrary institutions. I think it's going to be completely normal in 5 years to have such case management platforms. And I think where the competition, in a sense, will play out is how user-friendly they are. How easy kind of a plug and play it is, how easy you can sign on to them, how easy you can upload them. Maybe you can use AI to have hyperlinks. So if there's in a submission a reference to an exhibit, maybe the case management platform can automatically pull up the link, the exhibit. You could have, in a sense, like a LinkedIn feed, or for the older generation, like a Facebook feed, where it's actually graphically displayed what has been uploaded. And I think Mundi is very strong in that. Institutions can work on very quickly tweaking and improving their offering by having regular feedback. So Mundi, every time I log in, like two days later, I get an email, oh, let's have a half-hour video conference to improve our product. That's maybe a bit much, but this, I think, is a very good approach. So these are kind of the core, but also kind of already quite known enabling aspects. I think then there's some convenience aspects. I just talked about what is also quite common now, the electronic hyperlinks for tribunals in submissions, so they can easily jump to exhibits. I see that more and more in procedural orders. Hearing presentation software, I think there is a case management aspect where I think software will move away from just a mere PowerPoint we see, and I think already a lot of the larger law firms for the larger cases use much more sophisticated software. I think, of course, we'll have the predictive coding issue and how to deal with that. And I think that's actually a challenge for tribunals to make sure that is done in a proper way and there's proper guidance given. One quick side note, that's something I discussed yesterday, where there's still a bit of a disconnect. You sometimes have now very sophisticated presentation software in a hearing, but you're still usually limited to court reporting in live notes, kind of just paper transcripts. And so after the hearing, you might have seen great things, but the tribunal goes back half a year later when they finally start working on the award. And basically you just read, okay, let me take you to column E of Excel sheet so-and-so. Do you see that number? And what is missing is basically almost like a recording of how certain things were put up on the screen and how tribunals were run through visual things. So I think that's a bit of a challenge as well. So let me quickly, I think these are the enabling aspects. There's a lot to do, but also a lot is quite standard already. So it's really a matter of implementation. The disruptive aspects, to address that aspect, that goes towards due process and fairness. And I think one, of course, is the cost-benefit analysis or proportionality analysis. So horses for courses, that's what I mentioned earlier. There might be very big arbitrations and you can use a lot of digital tools. For smaller arbitrations, I've now am doing a very small arbitration, and the arbitrator sent us his standard procedural order with like all kinds of stuff, and we're like, oh, this is going to get very expensive. And actually the parties had a phone call and we started pushing back and said, like, we don't need all this stuff. So it was very sophisticated PO1, but it wasn't right for the case, and all the digital tools that were proposed were just too much. So I think that's really, in terms of case management, where arbitrators need to be careful. Second thing, of course, is the fairness principle, like how to preserve fairness. And in my view, parties should be allowed to use the technology they want if they can pay for it, because they can use the law firms they want if they can pay for it. So in the end, it's more an issue of cost allocation. If you win with all that technology or the expensive law firm, how much of the costs can you get awarded? But of course, a tribunal needs to step in at certain points in time. And I think that is when the IT solutions used in a case are not compatible. So basically one party sends across something and the other party says, I cannot open the document, I cannot see, I cannot understand your argument. So that's, I think, where the tribunal needs to step in. There might be the rare instances where actually technology is used to create a lot of burden on the other side, a lot of cost to overpower another party. I think that's rare, but again, a tribunal needs to be mindful of that. And finally, of course, there needs to be a need to prevent an ambush. So sometimes before the evidentiary hearing, suddenly there's other party sends across something that's based on certain technology, and you get surprised. So I think that needs to be managed by the tribunal. To conclude, maybe one more point where the tribunals need to be careful is data security, data privacy. I think that's a somewhat unexplored aspect, and especially with those tribunals that don't like technology anyway. And so the data security aspect is another even more complex aspect, and it's maybe a very boring aspect because it's kind of you need to think ahead. It doesn't really help your arbitration, and you have to put something in place to prevent something going wrong. So these are kind of the aspects I wanted to touch upon. And in terms of the preservation aspect, the third I mentioned, which is not on your slide, it's very interesting if you look into the model procedural order of the Campaign for Greener Arbitration. It almost reads like a procedural order using technology. Like a lot of it is overlapping in the sense that they say, well, we can make things much greener by using a lot of technology. So final point, what can UNCITRAL do? And I think in terms of case management, I don't think we need the next commission report or the next guideline. So the one aspect I think where arbitrators still need to be pushed, and maybe by UNCITRAL, is in the area of cybersecurity training, maybe put up platforms, webinars. I mean, I see this in my practice. I'm a big law firm, so we have automatically, as lawyers, we have those trainings. But even for me, it's really hard to sit through those little videos and things. And I think if you're an independently practicing arbitrator, you might not even have access to that on a periodic basis. So I think that might be a way to approach things.
Thank you so much, Lars, and especially for the final words about what UNCITRAL can do in this regard. So, and yes, I believe I do not really have requests for the floor, and I understand that the table is considerate about time, and we proceed finally to our final speaker, Pierre-Olivier, last but not least, to discuss a topic on interim measures on the preservation of aspects and other related issues. Please.
Thank you, Takashi. So I have the pressure of being the last one to present. I will try to be very efficient as much as possible, but I'd just like to have a word first to thank Lars for his very interesting presentation, which, raises issues of equality of the parties in terms of use of technology. And, as arbitrator, you should always, ask yourself, am I doing anything that will compromise the process, lead to any potential annulment. And I just wanted, and so that was interesting, and I'm going to cheat and take 1 minute to go back to AI before I do my presentation, because I really want to talk about the Colombian judgment, which Yas very kindly raised, where I don't know if everybody's heard about it, but a Colombian family judge wrote a judgment saying that he had consulted a ChatGPT on a question of Colombian family law, put the question to him, and said he agreed with the response and included it in the judgment. But he was very transparent about it. But it's not clear that he actually consulted the parties before doing that and putting it in the judgment. And I think that raises some extremely interesting questions. First, just imagine, would the judgment be recognized in France if somebody actually tried to take this Colombian judgment and have it recognized in France? And I think the answer would, there's issues. There's serious issues. And those serious issues would be the same, I think, with respect to an arbitral award, which go to both, in France, there's the principle of contradiction, which is a fundamental principle of French law under Article 16 of the Code of Civil Procedure, but is also one of the grounds to refuse recognition, enforcement of an international award. It's not a very successful ground, but because it's very hard to successfully raise, a problem with the principle of contradiction. But here you have the judge and potentially an arbitrator who would use ChatGPT, something external. To a certain extent, maybe it's like how do you a judge who takes judicial notice of something. So, what's the limit of judicial notice, but uses it. And the issue with ChatGPT, and this comes from my former colleagues, my younger colleagues in my firm who understand these things much better than I, who say, sometimes if ChatGPT doesn't know the answer, it just makes up stuff. So you've got a very serious problem where a question is posed, you actually don't really know what is used for the answer, and the parties haven't had the opportunity to contradict or put in a word about it. If the judge or the arbitrator was going to actually put it to them, that would probably solve the issue, possibly. But Yas in her presentation was making distinctions between the parties using AI for themselves. But this one is an example of the decision maker doing it. And I think that the caution when AI comes into the decision making process, I'm not saying that it should never be the case, but you have to ensure that the parties are able to contradict to ensure that the award can be enforced. And to a certain extent, this goes a little bit to Alexandre's presentation, where I've noted the problem is not the technology, but how it's used, which is, one of the consistent problems of technology. And I'm going to talk a little bit about digital assets in terms of interim measures, provisional measures, and Bitcoin. It can be used well. It can be used for money laundering. There's going to be a little bit of an example with respect to that. But I want to make 2 points on interim and provisional measures of digital assets. One, we need to remember the distinctions between the powers of an arbitral tribunal and the powers of domestic courts. And after that, the second question, I think, is that you need to understand the nature of the asset. Who holds the asset? And this digital asset, is there something fundamentally new about it, which requires adapting the approach to things? And as I mentioned earlier with respect to the electronic award, I think it's useful to look, my familiarity is with French enforcement law, but to look at how French enforcement law looks at different types of assets. And there's different ways, for example, to attach and sell, whether it's money in a bank account, whether it's a patent, whether it's a trademark, whether it's shares, an aircraft, ship. And the Code of Civil Enforcement Procedures in France has all kinds of different ways of dealing with different types of assets. And there actually are reasons for that, which usually and often go to actually who controls the assets, and therefore who has the responsibility of holding on to the asset while it's arrested. But we'll get back to that. So on the first question, in terms of the distinction between the powers of the tribunal and the powers of domestic courts, in France, it's Article 1468 of the Code of Civil Procedure, which in my unauthorized translation reads, the arbitral tribunal can order the parties under the conditions it determines and as needed under sanction of civil fine. In French, it's sous peine d'astreinte. Astreinte is a very difficult to translate word. Any conservatory or provisional measures it judges appropriate. So basically, the French law will recognize a very, very wide power, which goes to, provisional, anything, but also you can also impose civil fines for whatever reasons. But then it says in the next sentence, however, the jurisdiction of the state is solely competent to order conservatory attachments and judicial certies, sûreté judiciaire, to the extent anybody is wondering what the difference between a conservatory attachment and a sûreté judiciaire is just the second one relates to certain things like immovables or real estate, and the other ones to money and things like that. But the idea, and it's important, I think, from the perspective of the tribunal to understand this, that there are certain sovereign powers of the state to arrest goods which the tribunal doesn't really have. So when you craft your order, in this case, with respect to digital assets, there are certain things that you can't do or you don't have directly, they don't directly have the effect of, for example, arresting the asset. So there is, and you need to go into the domestic system to do that. And the types of things that, interim provisional measures, you can ask a party not to do something, or you can ask them to do something. You tell them, you have to put money or an asset into escrow, or you cannot do something, you cannot transfer the assets. And there's a New York court judgment from about 15 years ago which recognizes the power of a tribunal, if the parties agreed to give them such power, to force them to put the monies at stake into escrow. I found a judgment from the Paris Court of Appeal from 2004 which confirmed that the tribunal had the right, for example, to tell the parties not to change the composition of the board of directors of a company, and if they did, there was a potential penalty. It was they called it an astreinte, so of 700,000 euros if they breached that. An astreinte is something that is sometimes used here, for example, if a party is forced to live in an illegal attachment, you can try to convince the court that, from the date of the judgment, there can be 1,000 euros a day astreinte if they continue the illegal attachment. And French courts recognize this general power that is kind of consecutive to the interim measures power. So you can do that. But the question is, okay, so tribunals obviously have a power. Now we have digital assets. Is there anything new that we should take into consideration? And I'll give you one example, and it's the example of cryptocurrency. And this is something I learned about very recently, so hopefully I don't make too many mistakes in describing it. Maybe some people know a little bit more what this is, but it's hot wallets and cold wallets to hold cryptocurrency. As I understand it, the hot wallet is basically the platform which holds the currency for you. It's kind of like a bank, where if you have your money in the real bank, the way the holding the title is, the bank actually has the money and it owes you a credit. And anyway, so it seems to be a little bit like that, the hot wallet. And then the cold wallet is that you actually own the cryptocurrency, but what you have to know is that there's actually two assets. One is the cryptocurrency itself, which may be on a USB key, and the other assets, if you need to arrest the whole thing to make sure that it works, is the code, which may be on a sheet of paper, which may be on an electronic file. So for example, if you want, and that's kind of the analogy with French enforcement law, and it's possible to get arrests of cryptocurrencies. There's been, for example, criminal seizures of cryptocurrencies. But if you want to, the question is, if you want to arrest it, and now we're looking at, how enforcement works in the domestic jurisdiction, but there may be a useful analogy for the tribunal to understand how this would work if they're going to craft an order. If you want to arrest the hot wallet, you may have to notify the attachment to the platform and also probably to the holder of the assets through the platform. You have to notify it to two people. And if you're trying to arrest the cold wallet, basically, somebody putting money under their bed or something, you're trying to arrest two things. You're trying to arrest the code, and you're trying to arrest the USB key on which it is, but it's directly to the owner. And now the question is, so okay, once you've attached this, what is it? Is it like money, or is it another type of asset? Because if it was like money, this means that you could serve yourself directly out of it. Or is it more like a gold bar, which you will need to sell through a judicial sale because the price varies from one day to another? Because the price of gold is not the same every day. But if you have euros, so are bitcoins like euros, or are they like gold bars? 2 years ago, for example, there was a judicial sale of confiscated crypto, which means that, and also under French law, bitcoins and cryptocurrency are not considered money. So they're considered incorporeal assets. So you need to go through the judicial sale process. So you have this distinction, but you have to understand, how would you craft an order as a tribunal in terms of, making sure that the escrow works for the Bitcoin or for the cryptocurrency? Do you need to take into consideration who is holding it? And if the money is in a bank, how do you take that into consideration? They're probably not a party to the arbitration. So those are all I think relevant considerations for an arbitral tribunal, which will consider interim or provisional measures with respect to digital assets. And the question is, how do you understand the nature of the asset, who holds it, and how is it relevant to you crafting your interim measures order? For example, if you were crafting an interim measures order with respect to money, with respect to a patent, with respect to a trademark, with respect to shares, you may want to think about it differently. I mean, patents and trademarks are registered with the Intellectual Property Institutes. Shares, when they're arrested, the person responsible for them not moving is actually the company, not the owner of the shares, because they're the one who, keep the register of shares. The person responsible for money not moving usually is the bank. But when you're crafting the order from the perspective of the tribunal, how relevant is that? So, to the question, is there anything new about digital assets? Well, if there's anything new about how you characterize that as property, perhaps, and those are considerations that UNCITRAL should take into account. Thank you very much.
Thank you, Pierre-Olivier. You raised many important issues, and I'm sorry that we're not going to be engaged in discussions because of the time constraint, but our discussions will continue on this specific matter. And finally, I would like to invite Francesca from ICC to make brief concluding remarks and observations. Please.
Thank you, Takashi, and I will try and make brief the operative word. I think, first of all, just a thank you, obviously, for organising this event, and I think it really highlights the importance of bringing together all these different perspectives on what is clearly a collective challenge for all of us. And I think being able to first define those challenges and measure their impact is clearly going to be the first step before we can really look at, improving the framework in which we're all operating and looking at the kind of guidance that needs to be issued and the kind of support provided to users operating in our dispute resolution community going forward. I think what we've seen in all of the different sections of today's discussion is also tendencies trending towards the kind of efficiency and effectiveness of the case management of tomorrow, the impact that can have on costs and the benefits such as transparency. But also the fact that this is in many areas going to give rise to new opportunities for deliberate misuse of different examples of how these technologies play out. We all share, I think, across the community, again, cybersecurity issues. We're all going to be confronted with the technical issues that can come up in the kinds of technology that we're seeing, and also this impact of who is really monitoring the change and the impact on user behavior and our collective experience of how all of these innovations can change our working lives. So I think the importance of your work on all of ours is really clear. I think just to run through it from ICC's point of view, if I may, sort of some of the topics that were raised was, of course, is pithily titled AI in IA. I think we are really aware of this lack of data question, and I think it's something that as institutions we do have a responsibility to tackle, and looking at how we can do that on a much larger scale than what we're doing today, to examine very carefully in groups such as this the kinds of user behavior that we're hoping to change, to overcome reluctances to share specific information in case contexts. I think the question on electronic awards for right now in ICC plays out on a very regional level. And depending on which of the 12-team council you were to ask, I think you'd get a very different response as to where we are on that and how that's developing. So it's something that we, again, need to monitor and share so that we can collectively benefit from that information. On a technological standpoint, I think e-signatures were also raised, and that's something that, again, we need to build into the technologies, but we need to be very careful about what problem we're solving there. And again, through Alexandra's extremely interesting presentation, I think, again, questions were being raised of, how these things really play out in practice as well, such as the conflict checker, but also ICC's drive under Alexei Moore's presidency to share additional information via the website on the constitution of tribunals. And again, what we're seeing on an institutional level there is the same contradiction between the collective objective and the practical application on an operational level of who is actually willing to share what information in the context of cases. We see arbitrators calling the institution, asking, why is my name not present even though I was present in some of your cases? And of course, that's because it's in those matters where there was no agreement to publish that information. But again, on a sort of party level and at events such as there was this week, we also see the flip side to that, which is the concerns that are being raised and the potential negative impact of sharing that information, which is where the collective view can really benefit. And I think, lastly, in terms of case management, particularly, which is, of course, as you mentioned, Lasse, very sort of relevant to us on a practical level as we launched Case Connect in October, but also ICC has a number of other digital platforms and digital initiatives that play out in the background of supporting case management more broadly. And you're absolutely right to underline that there is no one-size-fits-all model. So I think in our technology, we're looking at these challenges of how you can build enough flexibility into your systems that mean that people can dip in and benefit from what's relevant to them without in any way obliging people to adopt behaviors that are not the most suitable and the most effective for their cases. And I think you also underscored the importance of taking feedback on board in contexts such as this and also directly in our daily work, and that's something we're trying to do. And I think the objective is, of course, to continue improving, and we're very, very glad to be able to collaborate with groups such as this. So thank you.
Thank you, Francesca, for concluding remarks, and we too look forward to collaborating with you. Let me take a brief moment to extend my heartfelt thanks again to Sciences Po for partnering with us, especially to Professor Arroyo here with us today, and also my dear friend Kyle. My warm thanks to all the speakers. Sorry for making the discussions a little bit of a rush at the very end, but your contributions are very useful for our purposes of the project going forward. And thanks to all the participants for joining. And as the world tour continues, we look forward to seeing you in other parts of the world. Thank you, and a great day to all. Thanks. And the recording stops here, and I just want to make one housekeeping announcement. Please take away your trash together towards the door would be fine. And also we have distributed questionnaires. If you might have time to take a moment to fill them in and hand them over to my colleague David, that would be very much appreciated. Thank you.